The case that Susan was mentioning at the very end of her comments had to deal with this text messaging case. And it literally just yesterday was the U.S. Supreme Court granted cert, which means the U.S. Supreme Court is going to consider these issues and render a ruling probably sometime in March. And it's a fascinating case. With all the new electronic ways of communicating, it really is going to be very interesting to see how the Supreme Court tells us we can deal with these issues. It involved a police department in Ontario, California. And what happened was they issued cell phones, government-issued cell phones to the police officers that obviously had text messaging capability. And they didn't have a policy specifically addressing the text messaging aspect of it. But they did have the general policy that says that the phones are the company's property and along with computers, and they have a right to search, et cetera. Where they got into trouble, number one, they should have had a policy that dealt with the text messaging, but everybody has 20/20 hindsight. But where they really got into trouble and why there really is a case, in my opinion, is because there was this practice that was put into place informally that allowed people to use the text messaging capability, and if they exceeded the 25,000 character limit a month, then the supervisors would go to the individual officers and say, okay, you exceeded it by this much pro rata, you should reimburse the department this much for that use. That it was argued, was an implied statement to these officers that it was okay to use these for personal reasons because they're paying for it. They're paying over the excess. And so based on that primary factor, the Ninth Circuit of California, the federal court that oversees our jurisdiction, ruled that they had a reasonable expectation of privacy in that texting, and therefore the way the department got in trouble was they contacted the cell phone service and asked them to provide them transcripts of the text messaging. Then they got the texts themselves and saw that a lot of them were sexually explicit, and that's what led to the claims against the officers and then ultimately the counterclaims by the officers. So this, I think, is a case to watch, because what you're going to want to do is you're going to want to try to monitor and manage these issues with whatever the Supreme Court, the U.S. Supreme Court says are the principles that should apply. We've known for a number of years, us lawyers and I would assume many business owners know that the real key is whether someone has an expectation of privacy. So whether it's their computer or whether it's their cell phone or voicemail, whatever it is, the electronic information or technology that they're using, you have to evaluate whether they have a reasonable expectation of privacy. And you may have a policy that says, this is our property, we can search it at any time, and you should have that if you don't have it. But even if you have that, be cautious. What you should take away from this Ontario Police Department case is be cautious about how you might be diluting that policy by statements that are made or practices that you have. If you have your employees contribute to some of the expense, it could be argued that that factor means that they should expect to be able to use it for their own personal reasons as well.